morning, everyone. Thank you very much for being here. I'm so happy to moderate this panel. I mean, I shouldn't tell this because I'm also panel coordinator, but I think we have today a very great panel, international and very well balanced in terms of background. So this panel is organized by PANELFIT. PANELFIT is a Horizon 2020 research project about participatory approaches to a new legal ethical framework for ICT research. And we will have time to talk a bit more about the project in, later. This panel will address quite critical issue, which is the role of informed consent in AI. So basically, one of the milestones of ethics and data protection, and how these milestones, so informed consent, which is not just in data protection, it's from health law, it's from sexual law, it's from several different fields, how this is still standing or maybe instably standing in the AI context. So we have, I'm very happy to present here our panelists. So starting from the left, we have Professor Amy Grant, a senior visiting fellow at UCLan, Cyprus. She works on a Fulbright scholarship about legal issues of emerging technologies. Then we have Matthias Spielkamp. He's co-founder and executive director of AlgorithmWatch, an NGO very much focused on automated decision making and data protection rights. Then we have Rob Shavell, co-founder of Abine, an online privacy company based in Boston. Then we have Albena Kuyumdzhieva. She's a program manager at the ethics and research integrity sector of DG Research and Innovation. She's also policy officer of PANELFIT. And dulcis in fundo, we have Iñigo Miguel de Beriain. He's a research professor at the University of Basque Country and also project coordinator of PANELFIT project. So, starting from Amy, we wanted first to address the issue of, the lack of consent in AI-driven context. So when data processing is the basis of AI, but this data processing really lacks consent, in particular in one of the most critical sector, which is commercial sector. So, Amy, I think we can, the presentation is the first, thank you. And you have the clicker if you want, or you want to be there? She prefers be there.
Thank you. So my background is primarily commercial. I was in-house counsel for various technology companies in the US for about the last 30 years. And the last 6 months I've been, as you mentioned, a Fulbright scholar at UCLan, Cyprus, focusing on legal issues with emerging technologies. And one of the areas that's of most interest to me is AI. And so I'm going to be discussing today the use of medical data in developing machine learning systems for analyzing medical data. So the goal is to develop systems using machine learning to improve diagnosis, treatment outcomes for patients in a wide range of healthcare settings. So I'm not focusing here on pure medical research. I'm focusing on developing the tools that will eventually help medical diagnosis and treatment. And the question is, how do you get enough information for the training data set for your machine learning systems while protecting patient privacy? and I apologize for my American accent, but I will say privacy, not privacy. Just a very brief review of GDPR. Patient records are full of special categories of data. So data concerning health, genetic data, biometric data, data identifying racial and ethnic origin, and data regarding sex life and sexual orientation. Now, the issue with the types of training data sets that we're talking about is you want a very rich trove of data so that you can find connections that you may not otherwise expect. So it's often important in developing the data sets to have the wide range of data, to have the demographic information, to have the full scope of the patient's records so that you can identify, so that as part of the machine learning, there's an opportunity to identify connections, relationships, patterns that might not otherwise have been obvious. So that's why having a wide range of data is important. However, under GDPR, processing special categories of data is prohibited unless you have consent, specific express informed consent, or the processing is necessary for medical diagnosis, provision of health or social care or treatment, management of health or social care systems, or it's pursuant to a contract with a health professional. We'll talk about how these were applied in the case of DeepMind. So I want to talk briefly about two circumstances in which Google obtained patient data that was not anonymized, that included a very wide range of data, and what the outcomes of those were. So DeepMind is a Google subsidiary developing AI. In 2015, Royal Free London National Health Service Foundation Trust doctors approached DeepMind and said, we would like better tools to be able to manage and use patient data. And so Google UK and Royal Free Trust signed an information sharing agreement, and the stated purposes were pretty broad. It was for building real-time clinical analytics, detection, diagnosis, and decision support to support treatment and avert clinical deterioration across a wide range of diagnoses and organ systems. And it specifically excluded sharing of data for clinical research. Okay? And Royal Free Trust started making the patient records available in 2015. They made available records on 1.5 million patients, anyone who had visited any of their hospitals for any reason, including 5 years of history back. Okay? So there was no data minimization. This was access to a very broad range of data. And nothing was anonymized. It was the full information. Okay, so DeepMind and Royal Free Trust announced a specific application of that, which was to identify patients at risk of acute kidney injury and to notify medical providers quickly. However, the data that they had access to was far broader than that. The actual population of patients for which that application would be appropriate was about 1/6 of the total population of the records that were provided. And so when this became apparent, there was an outcry. They responded. This is data processing to provide direct care. They didn't have consent. So this was to provide direct care. So Google was claiming that it was providing direct care to 1.5 million patients, even though the application that they said that they were developing was for 1/5 or 1/6 of those. I'm going to go through this fairly quickly. The UK Information Commissioner found that that collection and transfer of data did not comply with the pre-GDPR UK privacy laws. The patients were not adequately informed. Patients did not give informed consent. The use was outside the scope of reasonable expectations. DeepMind, and as part of when DeepMind was responding, they said, Google's not going to get this data. This is not going to be used for advertising by Google. We're DeepMind. We're keeping it in the UK. In 2018, DeepMind announced that the Streams application that had been developed was being transferred to Google, although Royal Free Trust objected and said that their consent was needed. So as far as I can tell, it has not been transferred, but I'm not positive about that. And in 2019, DeepMind published a research letter describing machine learning model for continuously predicting the future likelihood of patient developing AKI, acute kidney injury. So DeepMind did, in fact, use this experience to develop an app. They did not use the Royal Free Trust data. They obtained data from the US, from the Veterans Administration, to build their machine learning, their AI model. So what they discovered, because they didn't have consent, they did not use the National Health Service data for their AI data set, data training set. DeepMind has done other research projects where they did use anonymized, okay, I'm running out of information, I'm running out of time. DeepMind did use anonymized data for other AI development. So they learned from that not to use non-anonymized data. In the US, the HIPAA rules are different. Rather than being focused on the data subject like GDPR, HIPAA rules are based on the context, the organization. So they cover certain healthcare providers and related entities. They don't, it is not a broad data patient privacy coverage. But doctors can share medical data for use in treatment or medical administration or payment. They can share that with third parties who are business associates who are providing services. So they did that in 2018. Google started working with Ascension Health, which has 50 million patients. It appears that they made records available, non-anonymized records available to Google. The ostensible purpose was to develop an intelligent search engine to help Ascension doctors see all of the data for that patient. However, Google's not charging Ascension for that development, so there's no free lunch, there's no free development. Obviously, Google is doing that to develop commercial tools. So really the question becomes, I'm going to skip through this, the question becomes if a business associate is providing services and developing a commercial application using patient data, is there a violation of HIPAA? And I think the jury is out right now, so we don't know to what extent US patient record privacy is going to apply to the development of commercial products in the course of providing services.
We go to conclusion.
What's coming next is a case in Illinois where a patient whose records had been anonymized was provided to Google. He's suing. He says that Google has enough information to re-identify. He's suing for, among other things, on a class action basis, the royalty value of the data that was provided. So that it's a pretty interesting case. It's early in the stages, so we don't really know where it's going to go. And really my basic question is, when a vast trove of patient data is accumulated by a publicly funded health organization like the National Health Service, who should benefit from the use of that data? Should the patient individually benefit? Should the community benefit? Should only a private company benefit? So we need to be thinking about who benefits from use of private data.
Thank you.
I'm out of time.
Thank you very much, Amy. I think it was very interesting use case, and a lot of issues are on the table. One in particular is health data. anonymized algorithm, how an algorithm can be somehow still containing ethic issues. And now we go to a slide, we develop this topic in the field of diseased data subjects. So diseased data subjects data. And so Iñigo is going to present about this. The floor is yours.
Thank you so much, Gianclaudio. Thank you so much, everybody, for coming. As Gianclaudio was telling before, I'm acting as the coordinator of an EU-funded project. It is some coordination and support action in the Science with and for Society program. And well, I think it makes sense to say a word about the project, since we are somehow, the responsible for all this panel and some of the things that will come in the future. We are a project that is mainly aimed at providing a better knowledge of the data regulation, more or less, but also about some other things, such as, for example, cybersecurity and security issues. And one of our work packages, led by Gianclaudio, here present with us, will deal with that. We will focus on that. We will also focus on something that is not so often analyzed, which is the topic of the commercialization of data. Okay, so one of the parts of our project will have to do with that. But our main aim, it will be producing some outcomes that could make our lives easier for most of us. One, I think that the most important will be some guidelines for researchers in the EU. And these guidelines will serve somehow to harmonize things and tell researchers what they are supposed to do things well, okay? So that's one of the main products, and I think that it could be very interesting for most of you to keep an open eye to this. We will, of course, publish all our materials when they are ready. They will be publicly available, and I think that they could serve as a good basis to operate in terms of research, okay, in the new scenario created by the regulation. And once I've said that about the project, I will focus on my own topic. That, well, I think that it's quite an interesting topic and not so well explored till this moment. I will concentrate on the dead people, okay? It's a very interesting topic in terms of informed consent, because usually dead people cannot provide informed consent. They're just, quite peaceful people who never make complaints. And in so many, so they're very attractive for those people who want to take some data, because, they will not make any problems any longer, okay? So the point is that, moreover, our regulation is explicitly leaving apart data coming from dead people. So in whereas 27, it states that this regulation does not apply to the personal data of deceased persons. Member states may provide for rules regarding the processing of personal data of deceased people. So this in principle involves that provisions regarding data of deceased people are only protected somehow by specific rules at the member state levels. Of course, this rule exists, especially in some sectors. For example, we all know that most countries have some kind of regulation protecting secrecy in terms of healthcare, for example, and health records, are quite protected, and so on. There are some other spheres when there have been some regulation, and some countries are now developing new laws regarding what's going to happen with your data when you are dead. Of course, we all produce a lot of different kind of data when we are alive, especially now that we have kind of social networks and so on. So we produce a lot of data. Not all of them are personal data, and all of them come into the category of especially sensitive data and so on. So we have to make distinctions between them. We concentrate in some, I think that it's the most complicated data, that all those data that have to do with genetics and the health data and so on, because they are especially attractive, of course. So my point is that I'm not so sure if it is true that when you die, all those data are not or cannot be protected through the General Data Protection Regulation. I will try to explain to you that I don't think that this is the case, and I will try to explain why, okay? So we will start from, from something that you all have in mind, but more or less, keep it present that personal data means any information related to an identified or identifiable natural person. Data concerning health is where it is, and genetic data is where it is. So we have to keep always something in mind, that especially everything that's related with health data and genetic data, well, they are not so personal in so many ways. I mean, when you get some genetic data, yeah, they tell you a lot about you, but it also tells a lot about your relatives. I mean, the information that is contained in this data may come from you, and they could tell a lot of things about you, but they will also tell a lot of things about people who are connected to you, okay? This doesn't mean that all genetic data can tell everything about everyone. That's not the case. But at last, some of these data will tell a lot of things. So my point is that maybe it's we could consider that those data, when you die, are maybe no longer personal data of yours, but they might be personal data of some other people who are well connected to you. If we take this idea in mind, then the regulation could be applicable to this data. The only thing that will change is that the data subject as such will be someone else, but it doesn't mean that they are not linked to anyone. We're just, changing the subject, that's all. So if this were true, I mean, the regulation should be applicable to this data, and this means that nobody could use them without the same guarantees that if they were data related to an alive person, because they will be data related to an alive person. And for example, this means that those proposals that are talking about medical data donation lose a lot of sense, because if we consider that they do not belong to the dead people, then it doesn't make any sense at all, okay? You cannot give what is not yours any longer, okay? And finally, it's quite simple to do. It does not even mean that relatives could have access to everything that has to do with deceased people. This is totally different. They should only have access to those data that are also their own data in so many ways. And that's all. I will not extend anymore. I think that it was quite clear what I meant. Thank you so much, everyone.
Thank you.
For your attention.
Thank you very much, Iñigo. Yeah, and so, I mean, even shifting more from, this was post-mortem consent, no? And how this post-mortem consent can be. Two cases actually that both show how consent is somehow more problematic as we generally think. We generally think that consent, for example, in the health sector is a one-to-one relationship, but actually it's something more. It's algorithms that go beyond, or it's data processing that go beyond the life of a person. But now I'm happy to move to Matthias, so he's going to present about cases in which actually, I mean, this is the other view, when consent is not enough, in particular in public administration cases and in public registers. They do a great research about that, and they will show. It's the other one. Sorry, it's the PDF. Sorry.
Okay. Thank you very much, Iñigo and Gianclaudio, for the invitation. I'm happy to be here to add another perspective. It has already been fascinating. Who would have thought that the creators of GDPR didn't know what they were doing, right? But anyway, so I'll add an entirely different perspective coming from an organization, and I'll tell you a little about this, non-profit organization, an NGO, and we have the aim to evaluate and shed light on what we call algorithmic decision-making processes that have a relevance to society, meaning they are either used to predict or prescribe human action or to assist or make decisions automatically. This decision-making assistance was already mentioned here in Amy's presentation, when DeepMind said they were going to develop some tool that could help in making decisions, right? This is what we are focusing on, so we're trying to avoid using the term AI, because it's so ill-defined, and we'll try to focus on these decision-making processes. Now, where does the money come from? Always a relevant question when you're working for an NGO. This is our list of funders. Right now, it's private foundations. This year, we will also start to work with public money from German ministries. Now, what is our goal? We would like to see these automated decision-making systems benefit individuals and society, right? I mean, that's a very, very broad goal. And I'll dig deeper into that and explain to you how, for example, we can work out suggestions how that could be realized. Our position is that we are an evidence-based advocacy organization, so we have a lot of collaborations with scientists, academics, and we do participate in research grants, and this is how we try to gather the evidence that we think in a complex field like this is necessary to develop policy positions. We are not adversarial to government or the public sector or to private companies. We are not saying that these automated decision-making processes should not be developed. What is important is that these are developed in multi-stakeholder deliberation processes. We participate in those ourselves. So we work with governments, we work with private companies, and of course civil society to come up with these solutions. One of the case studies that we've done is the Automating Society report that we presented a year ago here at CPDP. We are working now on the second edition of this. And it's going to come out in the summer. Why did we do this report? Okay, because I don't even see the map on my screen here, but it is readable here. We argued that lots of automated decision-making processes are already in use in the European Union. But when you come to conferences like CPDP or basically every other conference that talks about algorithmic fairness and bias and so on and so forth, the only examples that are used are the COMPASS system in the United States and the Chinese social credit scoring, right? So we said that's not enough. We connected to 15 researchers from 12 different countries, these countries, and what we found is that automated decision-making is used widely for many different purposes. And I brought some examples. There was a system developed to identify children vulnerable to neglect in Denmark. One that tries to detect welfare fraud in the Netherlands, which by now is a very prominent case in the Netherlands. It's being discussed in court. There was already the trial, and we are waiting eagerly for the court's decision. Then allocating benefits to unemployed in Poland, also a system that has been abandoned. Detecting learning problems in primary and secondary schools to help teachers find so-called problematic pupils in Slovenia. Signing social benefits in Sweden, and of course predictive policing in many, many EU member states. All of these are examples of these automated decision-making processes that are used here. And in the 2020 report, we now added Estonia, Greece, Portugal, and Switzerland to the list of countries, and I can already tell you now that in all of these countries, we also found, surprise, surprise, these systems being used in the public sector, right? I mean, we did not look only at the public sector, we also looked at the private sector, but today I'm focusing on the public sector, so we did find them here. Now, of course, it's pretty clear awareness of this is lacking, and oversight is also inadequate. If you want to look up more of this, it's all on our website at algorithmwatch.org. Now, we developed a couple of recommendations out of this, and today I will focus on one of them because this is the perspective that I'd like to add here to this panel, and that is that we would like to see the public sector mandated to provide more transparency about the use of ADM systems. This would include where are they used, meaning what are they used for, what purposes, how, meaning what's the model that this is based on. We need explanations. Explanations, it's a big topic. I mean, I suppose everyone in the room knows or is aware of discussions about what explanations really mean and how they can be provided. But also, who were they bought from? Or also, I mean, they don't necessarily need to be bought from someone, but who developed them? Were they developed in-house, or were they, for example, just bought off the shelf from a company like IBM, Microsoft, DeepMind, whoever? And of course, make sure that adequate oversight bodies exist and are up to the task. And how would we justify such a register? I mean, first of all, the title is consent is not enough, because we think when we are discussing the public sector, you know, consent is not the idea that the GDPR itself had, because the public sector basically works on the basis of laws, right? So the GDPR says if there's a law, you can use these systems, and you don't necessarily need to ask for consent. You can't really escape it. You can't choose what police patrols you, what job agency is responsible for you. So this is why we see the public sector as a specific entity or a specific field that needs to be addressed with specific recommendations or demands. Now, I'll be using some examples from the paper or not presentation, it's like a recommendation that some some colleagues worked out for the Council of Europe, draft recommendations of the Committee of Ministers to member states on the human rights impacts of algorithmic systems. So what they're arguing is that in some cases the application of an algorithmic system may prompt a particular higher risk to human rights, for instance, because it is used by states for the public service or public policy delivery, and the individual does not have a possibility to opt out or suffers negative consequences as a result of the decision to opt out. So this is pretty much summing up what I explained. States should establish appropriate levels of transparency about the public procurement, use, design, and basic processing criteria and methods of algorithmic systems implemented by and for them or by private sector actors. And then the last, states should ensure that adequate oversight is maintained. So I have a minute, and I will tell you that, of course, this is a contested demand or recommendation. There was a study that came out recently by a Dutch law firm looking at or researching, doing a report on supervising governmental uses of algorithms, and they say, the authors argue, against the mandatory register of these far-reaching algorithms because they think there's a huge problem of definition. What exactly is it? So instead, public organizations should conduct an audit prior to developing new algorithms, and these audits should be made public then, right? So this is a contesting idea. I was part of a workshop organized by the University of Zurich in Switzerland, and we also published a paper on this that I mention here, and I will put the slides up on the internet so you can find the documents. And we argue that some of these ADM systems are potentially more harmful for individuals, groups, or the society at large than others, for example, e-recruiting systems as opposed to traffic lights. Hence, the potential impact of such an ADM system on people's life chances and social participation should be taken into consideration when carving out the scope of application or of a regulation. So basically, the result is there's lots to do when discussing these definitions and how we can apply these demands, and I will be happy to discuss those with you. Thank you very much.
Thank you. Thank you very much. So, I think you agree with me about the diversity of cases that we have on the table, and how actually the legal basis of consent is one, but not the only one. But what is the core is to be informed and to opt out at least. And Matthias was saying exactly this. So I'm happy to have also the business perspective here of a possible tool that could help in informing and opting out. And Rob will talk us about that. Thank you.
This one? Mm-hmm. And I can use the arrows. Can you use arrows? Great.
Good morning, everyone. My name is Rob Shavell, and today I'm going to talk about informed consent, and AI in the context of public records. I know a little bit about public records, at least in the United States, because I'm the co-founder of a company which opts people out of data broker records. So we're going to talk quickly about what are public records, a little bit about the history, and then get into some of the thornier issues about how this could potentially be regulated, what we can do, what we can't do, some ideas around that sort of thing. Public records have been around for a very, very long time, since the dawn of societies. Governments like to know when people die, which Iñigo pointed out earlier in his presentation. They like to know when people get married, have kids. They like to tax us all for these events. Public records, as a modern Western concept, started really in the UK in the 1830s, and today, as you can see over on your left of the slide, there's a lot of yellow and green. Over 90 countries now have frameworks, is what the word I would use to define what public records are, how they can be accessed, that kind of thing. If there are any journalists in this room, they're probably familiar with these things. It's a key tool that journalists use to get information about stuff they are looking into. The point I would make here is that most of this global legislation and understanding of what public records are and how they can be used is very new. It's only in the last 20 years have these have we globalized this. And in that same 20 years, the internet, as you're probably familiar with, has also matured quite a bit. And the internet companies have been busy with public records information as well. So at least in the United States, and I'd love to learn a little bit more about Europe, it's one of the reasons I'm here. If you Google somebody, you get a plethora of what we might call public records information. This is information that people have typically consented to in some form or another that's come from government records and or been scraped off of the web in various public places where people have ostensibly given consent. And you know, for those of us that are pre-millennials, sort of the internet is the new phone book. And as some of the panels earlier that you may have been to have discussed, you can start now doing really fancy things like reverse lookups from a picture to a bunch of information about an individual, from a phone number to a bunch of information about an individual. And the data here that these companies are collecting, these data brokers, the public records data, is pretty rich. You can see that there is information about specific individuals, their families, the ages of their families, their incomes. And my personal favorite on this slide, if you look at the bottom right, when you let developers and technical people do marketing, 0% married. I like to tell my wife at most days, at least, we're 70% married. So at any rate, there's a lot of information, and we know from being in the business of opting people out that both the prices of this information, which people are able to buy, and companies that are doing AI and machine learning projects are also able to buy, is falling. Meanwhile, the data, the richness of data, the number of points per record is increasing. In fact, our data suggests that there's 60% more data per record over the last 2 years that's for sale on individuals, at least in the United States. And it is being used all the time for AI. So, one question I had was, and maybe some folks in the audience can answer, is AI really different? When you combine this public records information, this personal data about us, is it different than putting it in a database? And I think one interesting thing is, and Amy touched on this in her presentation with the Google Health stuff, if you opt yourself out or opt a data set out and say, hey, I don't want that used in an AI project, after the model's already been developed, what happens? And I think the answer is nothing. That black box has already been developed, and it cannot be undeveloped. And so we have some really interesting, complex considerations that are specific to combining public records and AI that have never really been true before with plain old databases. And so that complexity is one of the big points of contention, at least when US policymakers and regulators start talking about how to address these kinds of issues with consent, public records, and AI. And sure enough, the two biggest problem areas that people are not able to agree on, companies, policymakers, and so forth, are who can get sued for what, and what kind of AI models and protections can we get around public records and not. And typical of at least Americans, when things become complex, we don't like them. Look at our president. When you survey us, you get, hey, we don't really understand this stuff, but we need to regulate it more. And I do think that the complexity itself is a fundamental and underlying problem here, which is not going away. So I would just touch briefly on sort of how we do this as a commercial company. We try to make this problem go away for people by making it really simple to outsource the problem and opt out of a whole bunch of different databases where we manage the complexity of the processes and things like that. And I do think this is an area that needs to be talked more about in this overall debate between regulators and enforcement. And in fact, I think that for-profit-driven companies, us and others, can help fill a gap in the enforcement of regulation and in the uptake of the rights that consumers have to both police and control their data, including their public records data and their consent data under the GDPR, CCPA, and future regulations. So to summarize, public records data is out there. We've supposedly given our consent to it, but it has now been totally and completely and efficiently aggregated by data brokers and technology companies. They've done a better job than governments at organizing this information. It is for sale, at least in the United States, to anyone for any reason, machine learning and AI included, except where it's legally explicitly prohibited today, such as in discriminatory lending or insurance. And we are able now to have the tools to begin to think about how to regulate this and watch its effects. And I would conclude with that we ought to be able to both regulate and help consumers make it easier to enforce all of the good work that so many people in this room have done for their rights under the GDPR and emerging legislation. Thank you very much.
Thank you very much, Rob. So a lot of issues on the table, some solution, but some further policy problems. In particular, there was one slide in which among the hard issues it was mentioned algorithm fairness. We are lucky enough to have a representative of Commission Research and Integrity unit. And she's dealing also with this concept of fairness, with this concept of AI as a policy goal. So Albena, the floor is yours, and thank you.
Good morning, everyone. My name is Albena Kuyumdzhieva, and I'm part of the Ethics and Research Integrity sector in DG Research and Innovation. We are responsible for the ethics policy and ethics oversight of Horizon 2020 project. For those of you who don't know, this is the biggest research and innovation funding program amounting at around 80 billion for a 5 year period. So, while listening to the wonderful presentation of my co-panelists giving different examples, now I want to take you a little bit back in the past. And do you remember the time that we actually have to go to the library to do our homework? Google was not existing. You remember the time when we were using these big maps and trying to allocate, okay, I'm here, and then we have to go there. And then actually we were going to the doctor and they were only using the stethoscope. And then we had to lit the fire to get some warmth physically. And then we had to go to the shopping mall and do the Christmas shopping and buy the best gift for our auntie who is always buying us these lovely Christmas sweaters that we like so much. So that was before. What is happening now, or in the very near future, we have now Google Maps, we have Waze, and if they don't work, we can actually get lost in our own city. If we don't Actually, soon we may not need them because we have the driverless cars, smart cars, that we just sit and wait and they drive us wherever they want. We have robots that are doing part of the jobs for the surgeons. We have smart homes where we can actually tell when to put our heating on, when to switch on the music, when to heat the water for the tea. And we have a personalized shopping experience. When we look at all these different situations, the question is, at what point of time are we going to, and are we willing to give our human autonomy, the very feature that defines us as human beings, that defines on how we want to live our life, how we want to shape our future, and exchange it for convenience? Are we ready to do this swap? Do we want to regulate our life and follow and change our values because we have new systems, new technological developments that push us to do so? Or we want to keep our human autonomy and actually regulate the technology in a way that it serves our well-being. It provides us the benefits that it was supposed to provide, while not violating not only our right to privacy and data protection, but our right to choose who we are and what we want to be. So how to navigate in this very complicated AI field and ensure that the right to choose is still ours? And then informed consent is one of the mechanisms that we are given under GDPR to help us do so. However, also hearing to what my fellow panelists were presenting, there are different situations and different settings and different AI area of applications where consent may not be appropriate, may not be enough, or it has to go further. So if we are looking back to consent and if we're thinking about facial recognition, facial recognition can be a great tool used by law enforcement authorities to detect possible criminalists, terrorists, radicalism, and prevent and ensure that we are living in a safe and secure environment. Yet, facial recognition without consent can actually bring us to a state of total surveillance, where the big brother is always watching. And the very thin line in defining where the boundary stays is probably how democratic is the society. But the level of democracy in the society also can change over elections and over views of how the voters vote. And then the voting of each one of us depends on what we are reading. And then to what extent we have the choice to see all the information that we want to read, and there is no algorithm behind saying, well, I profile Albena and put her in this box, so she will read most likely to like the opinion of this political party instead of this one. And then we go to the social scoring that was already mentioned. Are we happy to be put in a box where, in order to have a better score, we will modify our behavior in a way to please somebody, to please an algorithm, actually? So these are the questions that we have to address when thinking of artificial intelligence and the way ahead. And while the challenges are many, we have to think, can we actually deploy AI technology to serve innovation and to serve and protect human rights? Can we use it as a system that will ensure meaningful human consent? Can we use it, and then when I'm talking for consent, it can be either the legal basis or consent as a safeguard. Can we ensure the explainability and human oversight in all AI developed systems up to a point where we will actually trust? We are not going to be worried about potential false positives and negatives when somebody is trying to identify us as potential criminals or not. Because if we are thinking about consent, then we should always remember that there is a very thin boundary of what is that consent can make one activity legal and one activity absolutely illegal, because if I take your car without your knowledge and consent, this is theft, right? But if I take your car with your knowledge and your consent, it's just borrowing your car. So this is the differences that we should apply in thinking how to go further. And then in developing trustworthy AI, we have to embed the concept of ethics by design. And following the recommendation of the European Commission High-Level Group, Expert Group on Artificial Intelligence, ethics by design for AI or trustworthy AI system embed the element of legality, the element of technical robustness, which also ensures the reliability of the system, and the ethical element. And the human rights and the autonomy and the human oversight, the explainability, are all features that we have to think of. So going back to, is consent possible in the era of AI? I think yes. Consent is a very useful mechanism that provides either legal basis or safeguard. But apart from consent, we have layers that we also have to think of, because GDPR tells us that it's not enough to process data in a lawful manner, but it has to be also transparent and fair. And the concept of fairness and transparency is very much related on how we provide information and how we use the AI system and what we embed in the very design of the process. And going back again to what my fellow panelists said, data minimization is the key, starting from the research development stage, and embedding as possible information as needed in the system to ensure that our right of human autonomy is always there. The regulation of the ethical and legal aspects of artificial intelligence are among the political priorities of the new Van der Leyen Commission, and as a result of the communication on artificial intelligence that the Commission adopted in 2018 and the Integrated Action Plan on AI, we're looking at the steps and the procedure that will allow us to embed ethics by design for all AI projects developed in Europe and become, similar to GDPR, to become a flagship of this initiative, spreading them around the globe and ensuring that we, as a person, keep our human autonomy, we keep the right to be who we are, while innovating and advancing. Innovation should not be seen, ethics and the observation of human rights should not be seen as an impediment to development of new technologies and AI in particular. We should embrace ethics and regulation and GDPR embedded in the systems, and then innovate further, because this is what will give us also competitive advantage, and this is what will enable us to keep the values, to adhere to the European values, the ones that are enshrined in our Charter of Fundamental Rights. Thank you very much.
Thank you very much, Albena. So basically, I think that the problem of by design is as complex as the problem of explainability, because two different language, code and human language, that should somehow communicate, and the concept of fairness is so, problematic and vague. I would have so many provocations for our panelists, but I confess that in 3 years that we are using Area 42, this is the time I see Area 42 Petit the most crowded ever, so I'm sure there will be a lot of questions, so I will self-restrain and I will open the floor first to the question. You can please come here, there is a mic, if you have questions.
I only have a very quick question. First of all, it was a wonderful panel, so thank you. We hear about autonomy and consent, and we know it. We've heard it so often. And a consent has to be informed, otherwise it's not consent. And we have policy documents, and we have ethical committees, and so on. How do we ensure implementation of informed consent at the ground level? Because that's incredibly difficult. So I open that to the panel for your ideas.
Who wants to?
Truly informed consent, so the participant understands everything.
And free consent, maybe. Who wants to address this? Albena?
Well, unfortunately, I don't have all the answers. That would have been great. I mean, we are already testing. I mean, we've seen different examples of dynamic informed consent, of continuous informed consent. It is difficult for the consent to be truly informed, and we know it. We have examples of different labeling. You know that, like the energy efficiency labels, you can have a privacy labeling saying this is privacy friendly, and then we will read less. And if you see this is privacy unfriendly, we will read more, of course. And we had already privacy assistance technologies that are used as a proxy for our preferences. Of course, this all should be developed. But yet, when we are talking about informed consent, we should also not forget it's very easy to shift the whole burden of knowing what you agree to the research subject or to the data subject. We also have to share the burden of responsibility, because otherwise it's just, okay, read the terms and conditions and figure it out and agree. This should not happen. So this is why informed consent should be part of the holistic approach that we are taking in order to ensure meaningful control of the human and meaningful privacy protection.
I think Matthias wanted, but
yeah, just quickly. If you said something interesting, you said really understand it, or somewhat to that extent. And of course, we need to understand first what is meant by that, because if anyone here has the idea that informed consent only happens when we have understood the machine learning system that's behind it, there will be no such thing, right? So this is why we need to find ways to delegate this and to have some kind of system that, and here I would argue that informed consent, again, is not enough, because if we don't develop ways where such systems are audited by experts who have domain knowledge, and then have this escalating system of consent in the end, you know, that you need a trust structure that enables you to say, okay, I don't understand the machine learning system, but someone has looked at it, and I, for some reason whatsoever, have a certain level of trust in them. This will not work, because that's the same as informed consent, and Iñigo pointed to that, or maybe it was Amy, the history of that we've been talking about this not just in the data protection context, but when it comes to, for example, physicians and medical treatments, and we don't understand these things either, because we are not all physicians or biologists or whatever.
Yeah, and if I might have a word following you, I think that informed consent in some fields is not, I mean, as important as in some other, or maybe we should take a look at that in a different way. For example, in the case of healthcare, imagine that you have a kind of artificial intelligence system assisting a physician to make a good diagnosis of what you get. If you are the patient, you don't really need to understand how this artificial intelligence system works or anything like that. Not even the physician needs to know about that. It's enough that, for example, if the artificial intelligence is suggesting a kind of diagnosis and it rings a bell in the physician's mind, and he says, yes, it might be this, why I didn't think about this before, that will be enough. I mean, it's more or less what we really want with some of these things. So I do think that we have to make lots of difference depending on the kind of concrete case we have here. And I also agree with Albena that I think that in the future, technology could do well for us, in the sense that we could have also artificial intelligence assistants helping us to understand what is, for example, now when we sign a kind of license agreement, it's impossible for us to understand and spend some time reading this all. But in the future, we might have a kind of assistant that is telling us, pay attention to this and to that things at all. And I think that things will move in that way, and it will be easier for us. The main problem is that we are humans and we are fighting against a kind of very complex situation. But if we have some support from the machines, that will be in our part, I think.
Yeah. Just to add, there was a proposal from Shermer and Bart Costers about this intermediate legal basis between informed consent and legitimate interest. They call it like proxy consent, which I think in 2014, and now I think it's still very, very timely. I see other 3 questions, so we collect them and we reply, and then if there is another round and if there is time, so please.
All right. I want to cheat a bit because I have 3 questions for 3 different panelists, but 2 of them can be answered by just a simple yes or no. The first one is for Iñigo.
Okay.
When I extrapolate your arguments to the living, should then my children give consent if I want to do genetic testing?
No, I wouldn't say so, especially your children.
Even when they are adult children, or
yeah, but my point.
But,
my point is that in general, when you want to find that kind of information, you are the one who's most concerned about the results, and your intimacy is the most, affected by that. So you should be the one who's taking responsibility. This doesn't mean that you can do whatever you want with the information gathered. It's another thing. Okay, I think. Yeah.
Then a question for Rob.
But we collect the question and then we reply. So.
Okay.
Then question for Rob. You stated about the black box and retweeting your consent after the model was formed. Technically, it's possible to subtract data from a machine learning system. So shouldn't it be a logical result from the GDPR? For example, that machine learning should be prepared to subtract the data also. And then I have a question for Albena. And it's very much about keeping the humanity and human autonomy. Doesn't AI just work like any human or interaction, that when in that interaction you are determined, you lose humanity. And when the interaction has a dialogical character, you get humanity, you gain it. So shouldn't that be a main principle for designing AI systems?
We go with the other 2 questions.
They're slightly related, so it may be easy. The point is, probably consent should be put in a context, first in the context of the GDPR, where basically consent is fading away in a central role. I mean, the ADPB has already given an answer to that and urging not to use, in its clinical trial opinion, not to use consent, just because if consent is withdrawn and there is no other legitimate basis, legal basis, basically you have to take away from the model all the data which are relevant. Mm-hmm. That goes to the idea of putting consent in this broader context. If we want to tackle the role of consent, of not having consent, I think we have to tackle the broader concept is mostly before. So targeting someone for some proxy, so targeted advertising for political issues is a key example that can be and is used by artificial agents tools, because if they are targeting me for a bias, a cognitive bias, or my own experience on a specific niche, that can trigger me to switch. So to what extent, even if I give consent to get that targeted advertising, it's actually free consent. So I think we should look to the broader governance in order to get answers with starting from the point of dealing, no consent is necessary in many instances, and it's even dangerous. But on that, I would like to have your reaction.
Thank you.
Hey, thank you for an excellent panel. I'd like to pick up on the very good first question. And actually, I'd like to challenge the view that the data subject or the controller do not have to really understand the system that we call the AI systems. If you talk to a data scientist or a data researcher long enough, you will probably hear a term called software stack. And that means that usually, very often, the AI systems are not one models, but rather an agglomerate of a couple of models. And it just so happens that sometimes those models can be extracted and have a much more general use. Now, as you've noted, the models can be used to either through the use of the collective insights to identify an individual or re-identify the individual. So having all of that in mind and the complexities, obviously, in this, how would you say that affects the transparency requirement when it comes to obtaining a valid legal basis in this context?
Well, I have a fairly skeptical view on this, so I would say, first off, I think one question was, hey, can you retract data from an AI model? I think you can, but only if you rerun the AI. And I think in practice, like if you think about what happened with Google and the British hospital, I think in practice, if you really went in and talked to the Google engineers who built the model, by the time they had retracted the data for the consent when they were building, they had already built out enough information and intelligence in the model to get what they needed. So in the real world, opting out doesn't work, is sort of my point. And in terms of informed consent, it's just it's awful now, and it's sort of paradoxical, at least for Americans, and it's getting worse. I think perhaps a point of light is journalism. I think journalists are the people tasked with explaining complex stuff to the public and figuring out when different entities are going too far. And I think that if we have a strong set of journalists that partner up, and I know a bunch of them are here, that partner up with researchers who are able to do deep technical analysis, and they have the freedom of access to go into companies and get the data that they need to go run their investigations and then talk about it to the public, that's probably the best way that, in my opinion, you're going to start to get an informed public that has any prayer of making what we would call informed consent.
On the question with the dialogue with the AI, it's an interesting approach, but I think it's very much in the human nature that we kind of sometimes trust machines, and especially AI more, so that they bring facts, and then knowing how they operate, that their judgment is based on a lot of facts, we consider them smarter. So sometimes it's difficult to establish dialogue and argue with somebody that you consider smarter than you. And the interesting part is that when we are talking about the application of AI technology, in most of the case, the human is in the command. The human is the one who tells to the AI system what to do. And by commanding the system, and by the system knowing your preferences, actually this is where your human autonomy becomes to fade away. So it's a very interesting phenomenon that we have to explore from this perspective. And I fully agree with Giovanni saying that we need a broader governance structure that includes consent, but not only, that also will enable us to take all the specificities of the AI interactions and will also be specifically tailored to each domain, because as we already discussed, the application in medical research and healthcare provision will be totally different than law enforcement or public registers and provision of simple commodities.
Yeah, and if I can have a word, I think it's very interesting what you were saying about, for example, clinical trials and things like that. I think that we should always keep present that everything related to informed consent is much linked with healthcare, and everything was more or less developed from that kind of area. And I must confess that I've never felt so comfortable with some of the provision on this area. For example, when you take a look to some of the most relevant regulation tools in this, for example, Article number 2 of the Oviedo Convention or to the Helsinki Declaration, they both state the same, that the interest and the welfare of an individual human being must prevail against the interest of the whole society. I never understood that, due to a simple reason. I understand that the welfare must prevail, but why does the interest of a human being must prevail against the interest of a whole society? I never understood that. And I think that from that moment on, we built something that is not working so well. And for example, we are so used to be confident in individual autonomy and informed consent as something that is really relevant, and we are extremely unconfident on notions such as public interest in terms of legitimacy. I think it does not work so well in so many ways. It means that when we are on the application of the GDPR, it seems that informed consent is the only tool for legitimacy. It's not the case, and I think that it should be a kind of tool that should only be used in some cases, but not in all of them. I don't think that it makes a sense to work in that way. And I also think that we have something on the table. That is that it seems that we leave it all on the hands of the citizen that has to give consent or anything like that. But indeed it's not the case, because finally it is, in my opinion, the state that has to determine whether the consent was really informed or not. This could not be of thought and judged by the one who's giving consent, in my opinion. For example, in the case of clinical treatment, it is finally the physician who has to ensure that the patient is under the conditions to provide informed consent, and he has to say that yes, he really understood it and gave a kind of free consent. So I don't think that we must rely on the idea that citizens could perfectly consent on their own and in all circumstances, but then we need the state somehow to tell us when this is happening or not. So somehow we're enforcing the individual, but on the other side we are doing it in a way that really needs for the state to take a look at that. So it's quite complex in so many ways.
We have 1 minute question and 1 minute reply time. So if you want, yeah. And maybe Matthias wanted to add something?
No, go ahead first.
Yeah.
Otherwise we won't hear your question.
I thought I'd figured the answer out, which is why I sat down again. I used to be a securities lawyer, and I'm just wondering whether the asymmetry of information between a company that's seeking your investment and an investor, and the use of a summary in a prospectus could be useful here in terms of the consent, just thinking laterally. Obviously, there's a requirement to summarize under the existing law, but it's open to widespread abuse. You're still using 28 pages of consents, and certainly if you want to get your information deleted, you're going to have to go through, a cat and mouse game with highly well-funded and carefully constructed adversaries, for want of a better word. So just thinking about the fact that in the securities context, everybody cried foul and said, how can you possibly summarize 300 pages of a prospectus into a summary which we can be sued upon? But they did it. And that was because there was a clear enforcement strategy, and more importantly, there were resources to enforce that strategy. It's just a comparison that I've seen in a previous context work extremely well, but it all comes down to funding and will, and I just thought I'd make that point. It's not really a question, sorry. It's a free platform for me, but I apologize.
Yeah, thank you.
I think it ties well into, now the person who asked that last question that hasn't been answered yet has left already. I still take a stab at it, because I think it was a misunderstanding if you frame it like, okay, so if you can't understand it really, everyone can be left in the dark. This is not what I meant, and I don't think that's what anyone meant here. But what we cannot expect is that every individual can understand the complexity of these systems. So this is why we need these governance structures that are made up of, and it could be taking a sheet out of the book or of the prospectus writing or something like that. We need models for this. But a tired system where, first of all, we have standards for writing the code that make these systems better auditable and convey the information that we need to understand what comes out of it as a result. And on top of that, oversight bodies that are staffed with people who can understand what is happening there. And that will certainly lead to a structure where people then in the end said, when I go to a security check with my car and they give me that plaque in the end, then I'm fine and I don't need to understand how the engine works. So that's the idea, and not, it's complex, so we don't need to take care of it.
Yeah. So thank you so much. It was such an enriching experience for me. I hope for you too. And another round of applause for our panelists.